I was standing at my kitchen window drinking my morning coffee when I saw the HOA's snow plow rip through my entire front fence like it was made of cardboard. And I knew my peaceful Tuesday in Lakewood, Colorado was about to turn into an absolute nightmare. The sound was horrific. Metal scraping against metal, wood splintering, the screech of brakes that came way too late. I ran outside in my slippers, coffee still in hand, watching as the massive orange plow truck finally came to a stop about 20 feet past where my fence used to be. The whole front section was completely demolished. Posts snapped like toothpicks, panels scattered across my snow-covered lawn, and my gate was twisted into something that looked like abstract art. The driver climbed out of the cab, a guy in his 50s with a beard and a Carhartt jacket. He looked at the destruction, then at me, and I could see him mentally calculating how much trouble he was in. "I am so sorry," he said, walking toward me with his hands up like he was approaching a wild animal. The plow caught something, and I couldn't stop in time. I looked at what remained of my fence. I had installed it myself 2 years ago, spent 3 weekends measuring, digging post holes, making sure everything was level and perfect. It was a nice cedar privacy fence that had cost me about $4,000 in materials alone. Now it looked like a tornado had hit it. "How did you not see it?" I asked, trying to keep my voice calm. "The fence has been here for 2 years. The snow banks were high," he said, which was partially true. We had gotten about 18 inches over the past few days. I was following my usual route, but I think I came in too close to your property line. I took a deep breath. Accidents happen. I got his information, took about 50 photos with my phone from every angle, and told him I would be contacting the HOA board about repairs. He nodded, apologized again, and carefully backed his truck away from my property, the damaged plow blade scraping against the pavement. That was Monday morning. By Monday afternoon, I had already sent an email to the HOA board with all the photos attached, a description of the incident, and a request for immediate compensation to repair my fence. I figured this would be straightforward. Their contractor destroyed my property while performing HOA services. They should pay to fix it. Simple. I received a response Tuesday morning from Patricia Whitmore, the HOA president. Patricia was exactly the kind of person you would expect to run a homeowners association in a suburban Colorado neighborhood. She was in her late 40s, always wore pastel cardigans, and treated HOA rules like they were the 10 Commandments. I had dealt with her before when she had sent me a violation notice because my trash cans were visible from the street for more than 12 hours after collection day. I had explained that I worked late shifts and could not always get home in time, but she had fined me anyway. Her email was not what I expected. "Dear Ivan Johnson, thank you for bringing this matter to our attention. After reviewing the incident and inspecting the damage to the HOA plow equipment, we have determined that the negligent placement of your fence has resulted in significant damage to the plow blade. The repair costs for the blade and related equipment total $3,200. Please remit payment within 30 days to avoid further action. Regarding your fence, homeowners are responsible for maintaining their own property boundaries and ensuring they do not interfere with HOA operations. Best regards, Patricia Whitmore, HOA President." I read the email 3 times to make sure I was understanding it correctly. They were billing me for damage to their plow, the plow that had destroyed my fence, the fence that was completely on my property and had existed for 2 years without any issues. I called the HOA management office immediately. A receptionist answered and transferred me to Patricia. "Patricia, this is Ivan Johnson from Cedar Ridge Drive. I just got your email about the fence." "Yes, Ivan, I am glad you called. We need to discuss payment arrangements. Payment arrangements. Your plow destroyed my fence. I am not paying you anything. You should be paying me. Ivan, your fence was improperly positioned and caused damage to HOA equipment. We have maintenance routes that have been established for years, and homeowners need to ensure their property improvements do not interfere with those routes. My fence is 6 feet inside my property line, I said, trying to keep my frustration in check. I have the survey from when I installed it. It is exactly where it is supposed to be. Be that as it may, the fence created a hazard during snow removal operations. The repair costs are your responsibility. This is insane. Your driver hit my fence. I have photos. I have his admission that he came in too close to my property. I have spoken with the contractor, and he indicated that your fence was difficult to see due to snow conditions. This is a homeowner responsibility issue, Ivan. I want this to go to the board for a hearing. The board has already reviewed the matter. The decision stands. You will receive a formal invoice by mail. She hung up before I could respond. I stood there in my kitchen, phone still in my hand, absolutely stunned. This could not be happening. I had lived in this neighborhood for 5 years. I had paid my HOA dues on time every single month. I had followed every ridiculous rule they had ever sent my way. And now they were trying to charge me for the privilege of having my fence destroyed. The formal invoice arrived on Thursday. It was printed on official HOA letterhead and included an itemized list of damages. Plow blade replacement, $1,800. Labor for installation, $800. Equipment inspection, $300. Miscellaneous fees, $300. Total due, $3,200. Payment due by February 28th. There was also a separate paragraph at the bottom that made my blood pressure spike. Failure to remit payment by the due date will result in a lien being placed against your property and possible legal action to recover costs plus attorney fees and administrative expenses. I spent the weekend researching Colorado HOA laws. I learned that HOAs in Colorado have significant power, but they are not unlimited. They have to follow their own bylaws, they have to provide due process, and they cannot just make up charges without justification. I also learned that if they place a lien on your property for unpaid assessments, they can eventually foreclose. Monday morning, I hired an attorney. Her name was Rebecca Chen, and she specialized in HOA disputes. Her office was in downtown Denver, about 30 minutes from my house. She was in her mid-30s, sharp, and she did not waste time on small talk. "Tell me everything," she said, opening a legal pad. I walked her through the whole story. The Plow incident, the destroyed fence, Patricia's email, the invoice. I showed her all my photos, the survey from when I installed the fence and the threatening letter about the lien. "This is fairly outrageous," Rebecca said when I finished, "but not surprising. I see this kind of overreach all the time." HOAs sometimes think they are immune from basic liability rules. Can they actually put a lien on my house for this? They can try, but they would not win. This is not an unpaid assessment or fee that you legitimately owe. This is a disputed damage claim, completely different legal framework. So what do we do? First, I am going to send them a letter explaining that you dispute the charges and that their plow damaged your property. I will request that they pay for your fence repairs, or we will file a lawsuit. I will also inform them that any attempt to place a lien will be challenged immediately. Will they actually pay? Rebecca gave me a look that suggested she knew exactly how this would play out. Probably not. In my experience, HOAs like this usually double down. They hate admitting they are wrong because it sets a precedent. They would rather spend money on legal fees than back down to a homeowner. So we will end up in court, most likely. But you have a strong case. They damaged your property. You have photos, documentation, and a clear timeline. Their claim that your fence interfered with their operations is weak, especially since the fence existed for 2 years without any issues. How long will this take? If it goes to court, probably 6 to 8 months. Could be longer if they drag it out. I left her office feeling slightly better but also dreading the months of legal battle ahead. I had never sued anyone before. I had never been involved in any kind of litigation. The whole thing felt surreal. Rebecca sent her letter on Tuesday. By Friday, we had a response. It was from an attorney representing the HOA, a guy named Martin Crestwood from a firm in Colorado Springs. The letter was 3 pages of legal jargon that boiled down to this. The HOA denied all liability, maintained that I was responsible for the plow damage, and demanded payment within 15 days, or they would proceed with the lien. They hired a lawyer, I told Rebecca over the phone. Good. That means they are taking this seriously. Let them spend their money. What happens now? Now we file suit. I will draft a complaint seeking compensation for your fence damage. We will ask for the cost of repairs, plus your attorney fees, plus any other documented damages. How much should I ask for? What was your fence worth? Materials were about $4,000. My labor, if I had hired someone, would probably be another $2,000. So $6,000 for the fence. Let me check if Colorado allows treble damages for property destruction. I could hear her typing. Okay, no treble damages, but we can ask for attorney fees and costs under certain circumstances. Let me put together a demand that includes the fence replacement, your attorney fees, and compensation for your time dealing with this mess. The lawsuit was filed in Jefferson County District Court on March 3rd. I was suing the Pineview Meadows Homeowners Association for $6,000 in property damage, $5,000 in attorney fees, and $4,000 for emotional distress and time lost dealing with the matter. Total demand, $15,000. I knew the emotional distress number was a bit of a stretch, but Rebecca explained that you always ask for more than you expect to get. Judges tend to split the difference, and if we only asked for the fence cost, we might end up with less than we needed. The HOA had 30 days to respond. During that time, Patricia's harassment escalated. I started receiving violation notices for increasingly ridiculous things. My house number was not visible enough from the street. My mailbox was slightly faded and needed repainting. My front lawn had weeds that violated community standards. Each notice came with a fine, usually between $50 and $200. She is retaliating, Rebecca said when I showed her the stack of notices. Document everything. This actually helps our case. It shows a pattern of harassment after you asserted your legal rights. The HOA's response to the lawsuit arrived on April 5th. They denied everything and filed a counterclaim for the $3,200 in plow damage, plus $5,000 in attorney fees for having to defend against my frivolous lawsuit. They countersued me. I was sitting in Rebecca's office, reading through the response. Standard intimidation tactic. They are trying to scare you into dropping the case. Do not worry about it. Their counterclaim is nonsense. But it did worry me. Now, instead of just seeking compensation for my fence, I was potentially on the hook for $8,000 if somehow the judge sided with them. I started having trouble sleeping. Every time I pulled into my driveway and saw the temporary fence I had erected, I got angry all over again. Discovery was a nightmare. Both sides had to exchange documents, answer written questions, and sit for depositions. The HOA demanded copies of my property survey, all receipts related to the fence, my tax records for the past 3 years, and about 50 other things that seemed completely irrelevant. My deposition was scheduled for May 15th. It took place in a conference room at Martin Crestwood's law office in Colorado Springs. I drove down early in the morning, nervous, and rehearsed on what Rebecca had told me. Answer the question simply and directly. Do not volunteer extra information. If you do not know something, say you do not know. Martin Crestwood was in his 60s, gray hair, expensive suit, the kind of lawyer who was probably charging the HOA $300 an hour. Patricia Whitmore was there too, sitting in the corner with her arms crossed and a pinched expression on her face. The deposition lasted 4 hours. Martin asked me every possible question about the fence. When did I install it? Did I get HOA approval? Did I use a licensed contractor? How far was it from the property line? Had I ever noticed the snow plow coming close to it before? Why did I not install reflective markers? Why did I not inform the HOA of its exact location? Some of the questions were reasonable. Most were designed to frustrate me. Rebecca objected when necessary, but mostly let me answer. I stuck to the facts. The fence was on my property. It met all local building codes. It had existed for 2 years without incident. The plow driver hit it and admitted fault at the scene. But you agree that snow removal is essential to community safety? Martin asked at one point. Yes. And you agree that your fence may have been difficult to see in heavy snow conditions? I do not know what the driver could or could not see. I know the fence was exactly where it was supposed to be. But if you had used brightly colored markers or reflective tape, the accident might have been prevented, correct? I do not think I should have to mark my fence with reflective tape to prevent HOA contractors from driving into my property. Patricia made a huffing sound from the corner. Martin ignored her and kept going. When it was over, Rebecca patted me on the shoulder. You did great. He did not get anything useful. That was exhausting. Depositions usually are. Now we get to depose Patricia and the plow driver. Patricia's deposition was scheduled for June 3rd. This time it was at Rebecca's office, and I got to watch. Patricia showed up in a lavender cardigan and pearls, looking like she was attending a garden party instead of a legal proceeding. Rebecca was methodical. She started with Patricia's background, her role on the HOA board, how long she had been president. Then she moved into the incident. When did you first learn about the fence damage? Ivan sent an email on January 14th with photos. And what was your initial reaction? I was concerned about the safety of our snow removal operations, not concerned about the damage to Mr. Johnson's property. Of course I was concerned, but the HOA has responsibilities to all homeowners. We need to keep streets clear. Did you visit the site to inspect the damage yourself? Patricia hesitated. No, I did not personally visit. Why not? It was not necessary. I reviewed the photos. Did you speak with the plow driver? Yes. I spoke with Tom Hendricks. He indicated that the fence was poorly marked and difficult to see. Did Mr. Hendricks mention in that conversation that he had apologized to Mr. Johnson and admitted coming too close to the property line? Patricia shifted in her seat. He said he apologized, but that does not mean the HOA is liable. Who made the decision to bill Mr. Johnson for the plow damage? The board discussed it, and we agreed that homeowners need to take responsibility for ensuring their improvements do not interfere with HOA operations. But Mr. Johnson's fence was on his property, was it not? Technically, yes, but it still created a hazard. Had any other homeowner ever been billed for damage to HOA equipment? Patricia paused for a long moment. Not that I recall. So this was the first time in your tenure as president that the HOA has billed a homeowner for equipment damage? Yes. And why was Mr. Johnson treated differently? He was not treated differently. We were enforcing our rules. Rebecca spent another hour going through the violation notices Patricia had sent me after the lawsuit was filed. She made Patricia read each one out loud and explain the justification. House numbers not visible enough from the street. Can you explain what standard you used to determine Mr. Johnson's house numbers were not visible? The numbers should be clearly readable from the street during all weather conditions. Are they not? They could be larger. Have you sent similar notices to other homeowners with similar house numbers? I would need to check our records. But you do not recall sending such notices to others. Not off the top of my head. By the end, Patricia looked flustered and annoyed. Rebecca thanked her politely, and Patricia left without making eye contact with either of us. She is a terrible witness, Rebecca said after the door closed. She basically admitted on the record that they singled you out. The Plow driver's deposition was scheduled for June 20th. Tom Hendricks turned out to be a decent guy who was just trying to make a living. He worked for Mountain Peak Property Services, the company the HOA hired for snow removal. He had been plowing for 15 years and had never had a major accident before this. Rebecca asked him to describe what happened that morning. I was running my normal route through Pineview Meadows. It had snowed pretty heavy the night before, so the banks were high. I was coming down Cedar Ridge Drive, and I thought I had plenty of clearance on the passenger side, but I caught something. Next thing I knew, I was dragging the fence. Did you see the fence before you hit it? No, madam. The snowbanks blocked my view of where the fence started. By the time I realized I was too close, it was too late. What did you do after the accident? I stopped as soon as I could, got out and checked the damage. Mr. Johnson came out and I apologized. I told him it was my fault and that he should contact the HOA. Did you tell anyone else it was your fault? Tom nodded. I called my supervisor right away and told him what happened. I also filled out an incident report for the company. And what happened after that? My supervisor contacted the HOA, and a few days later I got a call from Mrs. Whitmore. She asked me what happened, and I told her. But then she started asking leading questions about whether the fence was properly marked, and if I thought it was in a dangerous location. I got the sense she was trying to get me to say it was the homeowner's fault. What did you tell her? I told her the truth. I came in too close to the property line and hit the fence. That is on me, not the homeowner. Did she accept that explanation? Not really. She kept pushing, saying the HOA could be liable and asking if I was sure it was entirely my fault. I told her I just plow snow. I do not do legal stuff. Rebecca got him to confirm that the fence was visible when there was not snow piled up, that he had seen it on previous routes, and that he had never had any issue with it before. She also got him to confirm that the HOA had instructed Mountain Peak Property Services to deny liability and to support the claim that the fence was improperly positioned. After the deposition, Rebecca was practically grinning. He just handed us the case. He admitted fault, and he testified that Patricia tried to coach him into changing his story. This is perfect. We filed for summary judgment in July, asking the judge to rule in our favor without going to trial. Rebecca argued that the facts were undisputed. The plow hit my fence. The driver admitted fault, and the HOA's attempt to shift blame was unsupported by evidence. We also included all the violation notices as evidence of retaliation. The HOA opposed the motion, arguing that there were disputed facts about whether the fence was properly positioned and whether I had taken reasonable steps to prevent the accident. They claimed they needed a trial to fully present their case. The hearing on the motion was scheduled for August 12th at the Jefferson County Courthouse in Golden, Colorado. I took the day off work and wore a suit. Rebecca met me outside the courtroom, and we went over last-minute details. The judge was a woman in her 50s named Teresa Kowalski. She had a reputation for not tolerating nonsense, which Rebecca said was good for us. Both sides made their arguments. Rebecca laid out the facts methodically, pointing to Tom's deposition testimony and Patricia's admission that the fence was on my property. Martin Crestwood tried to argue that HOAs have broad discretion in managing common areas, and that snow removal created special circumstances. Judge Kowalski listened to both sides, asked a few clarifying questions, and then said she would issue a written ruling within 2 weeks. The waiting was torture. Every day I checked the court's online docket to see if anything had been filed. Finally, on August 23rd, a new entry appeared. Order granting plaintiff's motion for summary judgment. I called Rebecca immediately. We won. Let me pull up the order. I could hear her typing. Okay, here we go. Judge Kowalski found that the HOA's plow driver was negligent in striking your fence, that the fence was properly located on your property, and that the HOA failed to present any evidence to support their counterclaim. She awarded you $6,000 for the fence, $4,000 for attorney fees, and another $5,000 for the retaliatory violation notices. Total judgment, $15,000. $15,000. That is exactly what we asked for. It is. Judge Kowalski basically agreed with everything we argued. She also issued an injunction prohibiting the HOA from further retaliation and ordered them to remove all the violation notices from your file. I felt a wave of relief wash over me. 8 months of stress, anger, and anxiety, and it was finally over. I had won. The HOA had 30 days to appeal. Those 30 days were nerve-wracking. I kept waiting for another legal filing, another fight, another round. But the deadline came and went without any action. They were not appealing. Rebecca sent a demand letter for payment. The HOA had 30 days to pay the $15,000 judgment. I was not holding my breath, but 2 weeks later, a check arrived in the mail. $15,000, signed by Patricia Whitmore with what looked like furious handwriting. I deposited the check immediately, half expecting it to bounce. It cleared the next day. The money was real. With the settlement money, I hired a professional contractor to rebuild my fence. This time I went with a composite material that would last longer and look better. The new fence was completed in October, and it looked fantastic. The contractor even installed it 8 feet inside the property line instead of 6, just to make absolutely sure there would never be another issue. The HOA went quiet after that. No more violation notices. No more harassment. Patricia remained president for the rest of the year, but I heard through neighborhood gossip that several board members had resigned over the lawsuit. Apparently there had been a contentious board meeting where some members questioned why Patricia had pursued such an obviously weak case and wasted thousands in legal fees. In January, there was an HOA election. Patricia ran for re-election, but she lost to a younger couple who promised to run the HOA more fairly and transparently. I did not vote for anyone. I just wanted to be left alone. The Plow incident became a bit of a legend in the neighborhood. Other homeowners started sharing their own stories of Patricia's overreach and ridiculous violation notices. A few people thanked me for standing up to her. One guy, Phil Anderson from Birch Lane, told me that Patricia had once fined him for having his garage door open for more than 2 hours during a Saturday afternoon when he was cleaning it out. "You probably saved us all a lot of grief," Phil said. Nobody wanted to fight her because they were afraid of getting targeted. But after what happened to you, people are not scared anymore. I appreciated the sentiment, but honestly, I would have preferred to just have my fence intact and avoid the whole mess. Still, there was something satisfying about knowing that Patricia's reign of petty tyranny was over. Spring came around again, and I was standing at my kitchen window drinking my morning coffee, just like I had been a year earlier. The new fence looked great. The snow was melting. The HOA plow truck drove by carefully, staying well clear of everyone's property lines. The new HOA board had hired a different snow removal company, one that apparently trained their drivers to pay attention. Life went back to normal. I kept paying my HOA dues, kept following the reasonable rules, and tried to forget about the whole nightmare. But every time I looked at my new fence, I felt a small sense of pride. I had fought back against an absurd overreach of power, and I had won. Rebecca sent me a final bill in March, which included a detailed breakdown of all the work she had done. Her total fees were actually closer to $6,000, not the $4,000 the judge had awarded, so I ended up paying $2,000 out of pocket. But considering I got my fence replaced and made a point about standing up to HOA bullying, it felt worth it. The new HOA board reached out in April asking if I would be interested in joining. I politely declined. I had seen enough of HOA politics to last a lifetime. I just wanted to live in my house, maintain my property, and be left alone. One unexpected benefit of the lawsuit was that the HOA became much more careful about how they enforced rules. The new board sent out a newsletter explaining that they would only issue violation notices for serious issues that affected property values or safety, not for minor aesthetic complaints. They also implemented a new appeal process so homeowners could challenge violations before fines were assessed. Several people told me these changes would not have happened without my lawsuit. The old board had operated with impunity for years, assuming that homeowners would not fight back because litigation was expensive and time-consuming. My case proved that you could win if you had the facts on your side. In May, I ran into Patricia at the grocery store. We made eye contact down the cereal aisle. She looked away immediately and pushed her cart in the opposite direction. I did not chase her down or say anything. There was nothing left to say. She had gambled that she could bully me into paying for something I did not owe, and she had lost badly. The HOA had paid out of their reserve fund, which meant everyone's dues had gone up slightly to replenish it. I had heard she was pretty unpopular with the neighbors now. Summer arrived, and I spent a lot of time in my backyard, which was private and peaceful thanks to my new fence. I hosted a few barbecues, invited some of the neighbors, and slowly built up a better relationship with the community. Most people were good folks who just wanted to live their lives without drama. The HOA issues of the past year had been entirely due to one person's need for control and unwillingness to admit mistakes. I sometimes wondered if things would have turned out differently if Patricia had just apologized after the Plow incident and offered to pay for my fence. It would have cost the HOA $6,000 instead of $15,000, and she probably would have kept her position as president. But people like Patricia do not apologize. They double down. They convince themselves they are right even when all evidence points the other way. And eventually, that stubbornness catches up with them. By fall, the whole incident felt like a distant memory. My fence stood strong through another winter. The new snow removal company did their job without destroying anyone's property. And the HOA board operated with basic common sense and decency. I even started to appreciate some of the things the HOA did well, like maintaining the common areas and organizing neighborhood events. In October, I got a letter from the new HOA board president, a woman named Sarah Mitchell. She apologized on behalf of the association for how I had been treated and thanked me for my patience during the transition. She also mentioned that they had updated the HOA bylaws to include stronger protections for homeowners and clearer procedures for handling property damage claims. I appreciated the letter. It showed that the new board understood what had gone wrong and was trying to fix it. I wrote back thanking her for the changes and expressing my hope that future homeowners would not have to go through what I did. Looking back on the whole experience, I learned a few important lessons. First, document everything. The photos I took immediately after the accident were crucial to my case. Second, do not back down when you know you are right. It would have been easier to just pay the HOA's ridiculous bill and move on, but that would have rewarded bad behavior and encouraged more of it. Third, HOAs are not above the law. They have power, but that power is limited, and judges will hold them accountable when they overstep. I also learned that standing up for yourself can have ripple effects beyond your own situation. My lawsuit changed how the entire HOA operated and probably saved other homeowners from similar harassment. That was not my goal when I started, but it was a meaningful outcome. The $15,000 judgment was more than just money. It was validation that I was right to fight back. It was a message to Patricia and the old board that homeowners have rights and cannot be pushed around. And it was compensation not just for my destroyed fence, but for 8 months of stress, frustration, and dealing with a system that was designed to be intimidating. By the time winter rolled around again, I could watch the snow plows go by without any anxiety. My fence was secure. My relationship with the HOA was neutral and professional. Patricia had moved on to presumably annoy people in some other context, and I had a story that I would probably tell for years to come. The funny thing was, I never wanted to be the guy who sued his HOA. I had always tried to be a good neighbor, follow the rules, and avoid conflict. But sometimes conflict finds you anyway, and when it does, you have to decide whether to cave or fight. I fought, and I won, and my only regret was that it took so long and cost so much energy. If I could give advice to anyone facing a similar situation, it would be this: know your rights, get a good lawyer, and do not let anyone intimidate you into accepting something that is fundamentally unfair. HOAs can be a useful part of community living, but they need accountability just like any other organization with power. As for Patricia, I heard through the grapevine that she tried to run for the board again the following year, but lost badly. Apparently the neighborhood had not forgotten how much money she cost everyone with her stubbornness. Last I heard, she was spending most of her time on Facebook complaining about politics and sharing recipes. A much better use of her energy than harassing homeowners over minor violations. The new fence became something of a symbol in the neighborhood. Other people started upgrading their fences and landscaping, knowing that the HOA would not harass them over minor aesthetic choices. The neighborhood actually started to look better as people invested in their properties without fear of arbitrary violation notices. I settled into a comfortable routine. Work, home, occasional neighborhood events. The drama of the lawsuit faded into the background. Every now and then someone would bring it up at a barbecue or block party, and I would tell the story again, and people would shake their heads at how absurd the whole thing was. Years from now, I will probably look back on this period of my life as a strange chapter. The year I went to war with my HOA over a fence and won $15,000. It sounds ridiculous when you say it out loud, but it was very real and very stressful while it was happening. The most satisfying moment, looking back, was probably depositing that check. Seeing $15,000 from the Pineview Meadows Homeowners Association in my bank account felt like justice in its purest form. They had tried to bully me, and instead, they ended up paying triple what my fence was worth. I kept a copy of the judge's order in my files, just in case. I did not think I would need it again, but it was nice to have proof that I had been right. The order was clear and unambiguous. The HOA had been negligent, their counterclaim was without merit, and they owed me damages. Judge Kowalski had not pulled any punches in her ruling. Life continued. Seasons changed. The neighborhood evolved. New families moved in and older residents moved out. The HOA kept functioning, now with better leadership and more reasonable policies. And my fence stood strong, a monument to the principle that sometimes you have to fight for what is right, even when it is exhausting and expensive and would be easier to just give up. I never regretted taking the case to court. Even during the most stressful moments, when I was lying awake at night worrying about legal bills and counterclaims, I knew I was doing the right thing. And in the end, the system worked. The judge saw through the HOA's nonsense, ruled in my favor, and awarded me everything I asked for. That is what justice looks like. Not perfect, not fast, but ultimately fair. And sometimes, that is enough. The story of my fence became part of the neighborhood lore. New residents would hear about it from longtime neighbors, usually as a cautionary tale about HOA overreach or as an inspiring story about standing up for yourself. I never tried to publicize it or make myself out to be some kind of hero. I just did what I had to do to protect my property and my rights. In the end, the fence was just a fence. But what it represented was much bigger. It was about whether homeowners have a right to defend their property against unreasonable claims. It was about whether HOAs can act with impunity or whether they face consequences for overreach. And it was about whether one person could stand up to an organization and win. The answer to all those questions turned out to be yes. And that made all the stress and expense worthwhile. Every time I pulled into my driveway and saw that fence, I smiled. It was the most expensive fence in the neighborhood, but it was also the most meaningful. It represented a victory for common sense, fairness, and the rule of law. And that was worth $15,000 of anyone's money, especially when it was Patricia Whitmore writing the check.